western lore. And by that standard tonight, we have one of the finest speakers that we have had, because we have the chief attorney of the Muskogee Regional Office of the Veterans Administration, and he's going to speak to us on early Oklahoma courts. It gives me a lot of pleasure tonight to introduce to you Joe Wallace.
Thank you, Phil Harris. It's indeed a pleasure to be with you tonight, and your kind remarks are deeply appreciated. I must confess that I cannot help but be nervous to address this particular group in view of the fact that you have in the audience here a gentleman whom I consider to be one of the greatest of all Oklahoma historians. In my opinion, there's none finer than Ed Gill, who knows his subject about Oklahoma history. Also, as I was waiting to come in to dinner tonight, a gentleman walked up and commented that he'd be most anxious to hear my remarks tonight. Mr. Brown pointed out that his father worked with Judge Isaac Parker at Fort Smith, Arkansas. Well, right there I knew at once that Mr. Brown probably knows more about early day courts in Oklahoma than anybody could. But I also learned that Mr. Sam Felt, who's with us here tonight, was born in New York, and then he spent 40 years in North Dakota and South Dakota, and he's only been here 2 years. So I'm going to dedicate my remarks to Sam Felt, hoping that I tell him something tonight. And perhaps my wife, Elva, maybe she won't know. My wife was born at Pauls Valley, Oklahoma. She's an Oklahoma girl. I was born at El Reno, Oklahoma, and grew up in Oklahoma, went to the University of Oklahoma, BA degree and law degree, and then was admitted to practice before the Oklahoma Supreme Court. Practiced law at Norman, Oklahoma, and World War II came, and that ended that. And at the end of World War II, I went to work for the Veterans Administration. I have dedicated my life to the law, which includes the courts. The courts are a part of the law. I've also dedicated my life to veterans, service of veterans. I've had a great interest in the history of our courts. And today, when we consider the issues before the Supreme Court, for example, whether capital punishment should or should not be abolished, and other issues that are before us today, I think it's very helpful to return and look at what did we used to do? What is our history? I think a lot of times that if you look back at history, it tells you what's going to happen tomorrow, because I think we repeat ourselves. A good example of that is just the United States Army uniform. If you look at the formal dress blue that is worn by the United States Army today in 1972, you see what they used to wear during the Civil War days. So they finally came back. Here we are again. And discussing the early day courts of Oklahoma, the first problem is, where do you start? We have had courts in this territory that's now known as Oklahoma for a long time. Certainly before 1907, which was our statehood. Certainly we had early day courts before April the 1st, 1889, which is probably the date that we ought to start with when you think about early day courts. But the Indian nations, the 5 civilized tribes, had courts. Later on, I'll mention some of their courts and some of the ways they operated. I won't try to cover all the 5 civilized tribes, but I will refer to it. But in trying to figure out where do you start in discussing early day courts in Oklahoma, I've chosen to take the Curtis Act of March 1st, 1889, and that is when Congress provided for the creation of a United States Court at Muskogee. Now, prior to this time of March 1st, 1889, there were no courts in the Indian Territory except those of the Indian tribes, and the white people who were here had no forum in which to be heard. They couldn't go before the Indian courts. So April the 1st, 1899 was the first white man's court, and it was organized at Muskogee, Oklahoma. And the first judge was James M. Shackelford of Indiana. Now, James Shackelford had been a general in the Civil War, and several of the members of his court also participated in the Civil War. An interesting note about Judge Shackelford, during the Civil War, he commanded the regiment that captured Morgan of Morgan's Raiders. And the first session of the court was held in a made-up courtroom in what was called then Phoenix Hall, over the printing office of the Muskogee Phoenix. Probably Phil knew that. But the first session of the federal court at Muskogee was a big event. It was a festive occasion. The streets were decorated with flags and bunting, and the town was crowded with visitors and their wagons, horses and mules and oxen. Lawyers were there from surrounding states, and everybody was interested in the first white man's court. And Judge Shackelford got off the train that came to Muskogee, and he was wearing a Prince Albert coat and a high silk hat. And later they crowded into this little courtroom above the Muskogee Phoenix. And after calling the court to order, prayer was offered by Reverend J.Y. Bryce, pastor of the Methodist Episcopal Church south of Muskogee. And at that session, the following officers filed their credentials. James M. Shackelford, the judge of Evansville, Indiana. S.T. Wellround of Osborne, Kansas, was the prosecuting attorney. Thomas B. Needles of Nashville, Illinois, was the marshal. And William Nelson of Indiana was the clerk. Court then adjourned to reconvene the next day at 9 o'clock. And at this session, the following lawyers were admitted to the bar. Now, I might stop at this point and mention that in the Indian courts, they did not have a bar. Anybody that felt able and willing and wanted to appear and represent a client could in the earlier days of the Indian courts. But the first members of the bar were D. Stewart Elliott of Kansas, Y.N. Foster and Napoleon B. Maxey of Illinois, Walter A. Ledbetter and G.W. Pasco of Texas, L.E. Jackson of Indiana, W.D. Crawford of Missouri, Ridge Pascal, E.C. Boudinot, Sampson O. Hines, and Robert L. Owen of the Cherokee Nation, Preston S. Lester, Joseph G. Rawls, J.H. Creighton, S.S. Fears, and J.H. Aiken of the Indian Territory. On Wednesday morning, Wayman Crow Jackson of Fort Smith was admitted to the bar, and at Thursday session, the court admitted James Bizzarola, W.H. Patterson, Leroy Neal, and Thomas George. The court appointed as jury commissioners for the June term P.J. Byrne, O.P. Brewer, and David M. Hodge, and for the September term, W.M. Martin, Charles LaFleur, and A. McKay. While the court was in session on April 3rd, 1889, the attorneys who had been admitted to practice met at 2 o'clock and organized the Indian Territory Bar Association. And the officers selected were Judge Shackelford as president, which is interesting since he was the presiding judge. He was elected the first president of the Indian Territory Bar Association. And Z.T. Waldron, vice president, R.L. Owen, secretary, and N.B. Maxey as treasurer. it might be interesting for you to know that one of the first issues to engage the attention of the court, and one of wide interest and importance, was whether an action would lie for recovery of a debt contracted before the creation of the court. And after an extended argument, Judge Shackelford held that it would in favor of numerous creditors. The Creek Council then endeavored to protect debtors in the tribe against actions by white men by the enactment of an exemption law, but the court held that ineffective. Another interesting historical fact is that the first jury called consisted of 33 Indians and 3 United States citizens. And one of the lawyers raised the point that that the jury couldn't try a citizen of the United States, and the court held that a special white jury was required. Now, during that session of the court, on June 24th, 1889, there was another big day in Muskogee history when they laid the cornerstone of the United States courthouse. Now, I hope that all of you know where the VA regional office is today, at 2nd and Court Street in Muskogee, Oklahoma. That was formerly called the Railway Exchange Building, and that was formerly the United States Courthouse. On June the 24th, 1889, approximately 2,000 people came to town. They had a spread of food set out on public tables, and they were all there to witness the ceremony conducted by the Grand Lodge of Masons of the Indian Territory. A group came from Parsons, Kansas on the trains, and then the Masons assembled in their hall over the post office about 10 o'clock, and at their meeting a special dispensation was read from the most worthy Grand Master of the Indian Territory, John Rennie, authorizing and empowering the right worthy Deputy Grand Marshal, Leo E. Bennett, to assemble the most worthy Grand Lodge of the Indian Territory to the special convention at Muskogee for the purpose of laying the cornerstone. And 17 officers of the lodge participated in the proceedings. Now, on the west side of the courthouse, there at 2nd and Court Street, Muskogee, was built a 2-story stockade which served as a jail in which the federal prisoners were confined. In 1893, some of the prisoners set fire to this jail. Now, the second, they built another stockade just between what is now 3rd and 4th Streets, just north of Denison Street in Muskogee. That was known in the Muskogee as the bullpen. It housed hundreds of prisoners, and they built a gallows there, a wooden gallows where they hung people. You wouldn't remember that. But this gallows was long a familiar sight to Muskogeans who had occasion to visit the neighborhood. I'm sorry, but I can't tell you the date that it was finally torn down. I don't have that information. But within that enclosure, 5 murderers were hanged at different times. Now, the Muskogee Bar Association, which was some different from the Indian Territory Bar Association, was organized on December 13th, 1889, with S.S. Fears as president, W.L. Hutchins vice president, R. Saris as treasurer, and H.O. Shepard as secretary. We can't really consider the early day courts of Oklahoma unless we consider what the 5 civilized tribes did about their laws. So I would like to mention first the Creek laws. Muskogee was, of course, in Creek territory. The Creeks had a chief executive at that time who was designated principal chief, And they had a judicial department and had a Supreme Court and several district courts. The district courts had general jurisdiction and the Supreme Court appellate jurisdiction. All of the officials were elected for 4 years by the male members of the tribe. Now, the laws passed by the National Council of the Creeks were both civil and criminal. And until the Indians came into active contact with the whites, they lived peaceably and with the minimum amount of crime. Indian Territory is perhaps the only section of the Republic where intoxicating liquors were never legally sold, which in some measure accounts for the absence of crime among the Indians. Now, the criminal laws of the Creeks were numerous and covered all crimes generally. Their laws did not provide for jails, penitentiaries, or other places of confinement. The Creeks had 2 forms of punishment: lashes upon the bare backs or death by shooting. 2 things could happen. You'd get beat on the back or be shot. They had a comprehensive criminal code covering all criminal offenses such as murder, mayhem, theft, perjury. But under their system, they saved a lot of money. We think about money today in 1972, and we think about our penitentiaries and what it's costing. The Creeks solved that problem. They spent no money. If a person was found guilty of a crime, immediately following the finding of guilty, there was the punishment. Appeals were not favored, or in some cases they were not allowed in criminal cases. And the Creek Nation had no licensed attorneys in the sense that we understand the term, but any person, a citizen of the Creek Nation, could be admitted to practice in the courts with little or no preparation. And so, naturally, there was a total absence of quibbles and technical objections. And today, I'm sure you'll agree that sometimes we might have too many technical objections, quibbling. Some of the judges of the Creek Nation were uneducated, and some of them did not understand the English language, which the English language is the language used for their court records. And it's interesting that the Supreme Court of the Creek Nation opened its daily sessions with a prayer by one of the judges, and then if the man was found guilty, they stripped him to the waist, and his hands were lashed to the branches of a nearby tree. Whichever, didn't matter which tree, just a nearby tree. And the executioner, they called them the light horsemen, had an ample supply of long and supple switches, and each of the members of the light horsemen gave him a share of the number of switches. Now, they had a limit. You could not be switched more than 100 times, but it was not unusual for a person that received 100 lashes to die. That did happen. Now, it is noted in the literature that this form of punishment was very effective and was seldom repeated. Usually the person that took his lashes, he didn't want to come back. That was it. And there are a lot of people that think this might be a good thing to have as a form of punishment today. For example, a wife beater, hang him up the nearest tree, give him some lashes.
How about a husband beater?
No, husband beater. No. The last instance of capital punishment in the nation occurred at Muskogee in 1898. I think this is an interesting story about Tom Chickasaw. Tom was a Creek Indian, and he was charged with horse larceny. He was arraigned before Judge Freeland Marshall, one of the judges of the district court. The prosecuting officer was a colored man, a freedman citizen of the Creek Nation. The case against Tom was technical to a large extent as far as the facts were concerned, but Tom had a bad record. Twice before he had been convicted of larceny, for which he had been duly whipped. His first offense, he stole a polecat skin, and they gave him 39 lashes for stealing a polecat skin. This time he was brought to trial before the jury, and in due time a verdict of guilty was returned, and since it was the third offense, he was sentenced to death. No appeal was taken, but every effort was made to obtain a pardon from the principal chief. Tom was delivered by the court to the light horseman for execution. He was given the usual time to arrange his business affairs and released with no other recognizance than his own word that he would return. And today in our system, a man charged with murder and sentenced to death, found guilty and sentenced to death, can't get bail, can't get out. But in the Creek Nation, they let him go home. He just gave his word that he'd return. And the literature indicates that no full-blood Indian ever broke his word or violated his promise. If he'd been tried in court and told to go home, they went home and came back. And sure enough, Tom Chickasaw, in due time, presented himself for execution. He walked up, here I am. He sat under the shade of the trees there at Muskogee in the yard of the Capitol building, while across the street a carpenter built a coffin for Tom. He watched him build it. And across the creek from the building was the old Indian graveyard with its mounds and burial structures. And as the sun was dipping to the west, a wagon containing the rude coffin drew up to the front gate of the Capitol grounds to convey the convicted man to the place of execution. And with a grim face, Tom got on the box and with a grunt of farewell to his only sister, rode away. The little procession wended its way across the creek to the old burial grounds, and then Tom, with a patch of white paper over his heart and squatting upon his heels, was placed with his back against an oak tree. Two light horsemen with loaded rifles aimed at the patch of white, fired, and Tom fell forward upon his face, and the tragedy was closed. The point I want to make about the laws of the Creek Nation is that the laws were righteously and rigidly enforced, and the high state of morals of the Creek Nation before its contact with the whites was due in no small degree to the uncertainty with which punishment would be inflicted. Now, a word or two about the Cherokees. In the old days, Cherokee courts had no reporters and stenographers, and stenographers with their shorthand notes were unknown. But in Cherokee courts, all questions, answers, and rulings of the court and the proceedings were taken down in longhand, and in many instances where full-blooded Cherokees were parties, their testimony had to be interpreted into English, and all English-speaking witnesses interpreted back into Cherokee, and the full-blood witness was given to going into minute details before he could get down to the material testimony in the case. Coming back to the date of March 1st, 1889, one of the last cases that was tried by the Cherokees in their courts was a man, a member of the Cherokee Nation, that killed another citizen of the Cherokee Nation. And Mr. Thompson made a speech to the Oklahoma Bar Association about this particular case. And this man was sentenced by the Cherokee Nation to be hanged. And a commitment was issued that he be confined in the National Prison at Tahlequah until the day of execution. And on the day of execution, that he be taken from the jail and hanged by the High Sheriff of the Cherokee Nation. Well, on his way from the court where he was tried to Tahlequah, about 20 miles away, he escaped from his guards. You see, he had not been asked to give his word to come back. He was in custody, and that was a little different. If you were in custody, you could get away. That's something else. You hadn't given your word. But this man did get away, and a few months later, he came in to see this lawyer and told him his story and his problem. And he said, what should I do? The courts of the Cherokee Nation have now been abolished by reason of this act of Congress. And so the lawyer advised him, well, since there are no more Cherokee Nation courts, go on home and live and be a good man. And he did. That's the end of that story. That's the last case of conviction by the Cherokee Nation. Now, before March 1st of 1899, we had territorial courts, and in those pre-statehood days, before Oklahoma became a state, we know that we had a number of bad men in Oklahoma. We had men who had an itching trigger finger. We had cattle rustlers and horse thieves, and somehow we needed justice. But it's interesting that there were very few Indians involved in those courts and those cases because the Indian nations took care of their own problems. But one interesting case that came up before Judge Joseph A. Gill is the story of the full-blood Indian who did come before his court, because in those days young Indians saw no need of taking out marriage licenses before being married. And the older full-blood Indians felt that a half a dozen wives in one house was just about right. Just about right. But unfortunately, going through this legal process, a full-blood chief was brought before this territorial court with a charge of bigamy. And according to the prosecution and the evidence, the old chief had been living with 4 wives in one house. Judge Gill listened to the proceedings and then addressed the chief, who could speak no word of English, and asked the question, don't you know that the law allows a man but one wife? Now go home and choose the wife you want to keep and tell the other 3 they must leave. This order was translated to the chief, who grunted several times by way of reply. The interpreter said, he wants you to tell him again. What'd you say? The judge said, well, tell the 3 wives that you don't want that they have to pack and leave. And the big chief stood up and grunted, and the judge asked the interpreter, what'd he say? And the interpreter says, he says for you to tell him. The work of the courts was too much to handle, so there became a division of the territory, and the 3 districts of the federal courts were known as the Northern, which embraced the Quapaw Nation, the Cherokee Nation, the Seminole Nation, and nearly all of the Creek Nation. The Central District consisted of a small part of the Creek Nation and part of the Choctaw and Chickasaw Nations on the east side, held by the Choctaws, and the Southern District composed of that part of the Choctaw and Chickasaw Nations occupied by the Chickasaws. And for the purpose of the tape recording and the history, the judges of these districts were, for the Southern, C.B. Kilgore, and later Hosea Townsend, and for the Central District, Charles B. Stewart, succeeded by Yancey Lewis, and later by William H. Clayton, and for the Northern, first William Springer, and later Joseph A. Gill. As the work of the courts became more and more involved, an additional judge was appointed to assist the 3 judges already in office. The places Muskogee, Wewoka, Tahlequah, Veneta, Wagner, Miami, and then later Bartlesville, Nowata, Claremore, Sallisaw, and Pryor were added to the list. Now, if you can imagine the workload in one of these courts, in the morning at 9 o'clock, the bailiff and the marshals would bring in 20 to 40 prisoners, and the judge would start hearing the cases of each individual. So it was usual for a court to go on till 10 o'clock at night. And upon the conclusion of a term of court, the government would send in a passenger train and load up the prisoners, and they'd put them in charge of a marshal and then spread them out to the different penitentiaries throughout the United States. And the population of this part of the time was made up of Indians, Negroes, and whites. I think that with that background of the period of the 1890s coming up to 1970, I think we have to mention specifically the Eastern District Federal Court of Oklahoma, and the jurisdiction of that court has changed. Approximately 3 years ago, it has been changed to provide that Comanche County and that far western part has now gone to the Oklahoma City jurisdiction of the federal court. The first federal judge of the Eastern District of Oklahoma was McAllister attorney Ralph Camel, and he had the pushing of Theodore Roosevelt's Rough Riders. And President Theodore Roosevelt originally endorsed another candidate, but finally he appointed Ralph E. Camel as the district's first judge. And several years later, the next federal district judge was Governor Robert L. Williams, and he won the bench in 1919. Bickering was widespread about his appointment, stemming partially from the strong support of Senator Thomas P. Gore, who he supported this controversial Williams. But at the time, Gore was in hot water over his opposition to President Woodrow Wilson in World War I. Lawyers, most of the stories that are told of most interesting events have to do with Judge Robert L. Williams. I can only relate one personal experience, that when there was court being held in McAllister, Oklahoma, trucks were going up and down the road and making too much noise to suit Judge Williams, so he ordered the marshals in and sent them out and sealed off the main street of McAllister. He didn't want any noise while he was holding court. And for that day, there was no noise in McAllister, Oklahoma, except the lawyers talking. The next judge following Judge Williams was Judge Eugene Rice of Duncan, Oklahoma, and he was appointed in 1937, being the district's third jurist. And the story has been told that he was actually a compromise recommendation of two United States Senators, Elmer Thomas and Josh Lee. And Rice was actually regarded as Lee's choice, but he lived in Thomas' home territory of Duncan. And of course, the present judge of the Eastern District of Oklahoma is Judge the Honorable Edwin Langley, and he was appointed with the general agreement of all concerned that he should be appointed. In trying to prepare remarks about the early day courts of Oklahoma, it's very difficult to know what to take and what to leave out. I want to close my comments for tonight by going over with you the court records of an actual case by Temple Houston. Now, this was a plea in district court at Woodward, Oklahoma, in May of 1899. And I want to give you the actual language so that you can picture the colorful method of speaking of the lawyers of that day. Incidentally, Temple Houston was the son of Sam Houston, a great Texas hero, also hero of Fort Gibson, among other places. But in the closing argument of this case, involved Minnie Stacy, and she was prosecuted for plying her vocation and running a bawdy house. And there was something about the case that aroused the indignation of Temple Houston, who instantly undertook her defense. So the prosecution had made its case, and the defense brought their witnesses, and now here is Temple Houston addressing 12 good men and true, the jury. And these are his words. Gentlemen, you have heard with what cold cruelty the prosecution referred to the sins of this woman, as if her condition were of her own preference. The evidence has painted you a picture of her life and surroundings. Do you think that they were of her own choosing? Do you think that she willingly embraced a life so revolting and horrible? Ah, no. Gentlemen, one of our sex was the author of her ruin. More to blame than she. Then let us judge her gently. What could be more pathetic than the spectacle she presents? An immortal soul in ruin, where the star of purity once glittered on her girlish brow. Burning shame has set its seal forever, and only a moment ago they reproved her for the depths to which she had sunk, the company she kept, the life she led. Now, what else is left for her? Where can she go and her sin not pursue her? Gentlemen, the very promises of God are denied her. He said, "Come unto me, all ye that labor and are heavy laden, and I will give you rest." She has indeed labored and is heavy laden, but if at this instant she were to kneel down before us all and confess her Redeemer and beseech his tender mercies, where is the church that would receive her? And even if they accepted her, when she passed to the portals to worship and claim her rest, scorn and mockery would greet her, and those she met would gather round them their skirts the more closely to avoid the pollution of her touch. Would you tell me a single employment where she can realize, "Give us this day our daily bread"? Our sex wrecked her once pure life. Her own shrink from her as they would the pestilence. Society has reared its rentless walls against her, and only in the friendly shelter of the grave can her betrayed and broken heart find the Redeemer's promised rest. They told you of her assumed names, as fleeting as the shadows on the walls, of her sins, her habits, but they never told you of her sorrows. And who shall tell what her heart, sinful though it may be, now feels, when the remembered voices of mothers and sisters, whom she must see no more on this earth, fall like music on her erring soul, and she praised God that she could only return, and must not, no, not in this life, for the seducer has destroyed the soul. You know the story of the prodigal son, but he was a son. He was one of us, like her destroyer. But for the prodigal daughter, there is no return. Were she with her wasted form and bleeding feet to drag herself back to home, she, the fallen and the lost, what would be her welcome? Oh, consider this when you come to decide her guilt, for she is before us, and we must judge her. They sneer and scoff at her. One should respect her grief, and I tell you, there reigns over her penitent and chastened spirit a desolation now that none, no, none, but the searcher of all hearts can ever know. None of us are utterly evil. And I remember that when the saffron scourge swept over the city of Memphis in 1878, a courtesan there opened wide the doors of her gilded palace of sin to admit the sufferers. And when the scythe of the reaper swung fast and pitiless, she was angelic in her ministry. Death called her in the midst of her mercies, and she went to join those she tried to save. She, like those the Lord forgave, was a sinner. And yet, I believe that in the day of reckoning, her judgment will be lighter than those who persecute and seek to drive off the earth such poor unfortunates as she whom you are to judge. They wish to find this woman and make her leave. They wish to wring from the wages of her shame the price of this meditated injustice, to take from her the little money she might have. And God knows, gentlemen, it came hard enough. The old Jewish law told you that the price of a dog, nor the hire of such as she, should not come within the house of the Lord. And I say unto you that our justice fitly symbolized by a woman's form that does not ask that you add to the woes of this unhappy one, who only asks at your hands the pitiful privilege of being left alone. The Master, while on earth, while he spoke in wrath and rebuke to the kings and rulers, never reproached one of these. One he forgave, another he acquitted. You remember both. And now, looking upon this friendless outcast, if any of us can say unto her, I am holier than thou, in the respect with which she is charged with sinning, who is he? The Jews who brought the woman before the Savior have been held up to the extirpation of the world for 2,000 years. I always respected them. A man who will yield to the reproaches of his conscience as they did has the elements of good in him. But the modern hypocrite has no such compunctions. If the prosecutors of this woman whom you are trying had but brought her before the Savior, they would have accepted his challenge, and each one gathered a rock and stoned her in the twinkling of an eye. No, gentlemen, do as your Master did twice under the very circumstances that surround you. Tell her to go in peace. The jury acquitted her at once. The old court records contain beautiful language, fascinating cases, and it's with deep regret that I do not have time to go into more. Thank you for allowing me to be with you tonight.